am Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and today I'd like to explain a circumstance where a revocable living trust can become irrevocable. But before I get started, if you ever have any questions regarding a Northwest Indiana estate planning matter, you can always reach out to me at indianaestatemeeting.com, and I'll be more than happy to spend a few moments with you, answer your questions, and see if we can get something done for you. So here is a factual scenario. You have a guy who is single, divorced, widower, but he is single at the end of his life. He has 2 children. He decides to prepare or have prepared for himself a revocable living trust. And as a reminder, a revocable living trust is just a box. And then you, in order to have to go and put stuff or title stuff in the box. So he goes ahead and he funds the trust, puts his house in the trust. He puts some beneficiary designated stuff in the trust, like life insurance in the trust, and things along those lines. He has 2 children. And his concern after he passes away is that he wants to be able to protect the assets for his kids, whether it's from spouse or creditors or things along those lines. He also wants to avoid probate. Thus, he prepared the trust. So during his lifetime, because he is the initial settlor or grantor, and he is the initial trustee, he can go ahead and do whatever he wants in that trust. He can amend it. He can revoke it. He could take the house and put it in the trust. He could take the house and put it out of the trust. He can do whatever he wants. It is a revocable trust. But he sets up at the time that he passes away that the money will flow to his kids in separate share trusts. And if he wants to have an asset protection component to it, he needs to have more than one trustee if he's going to have his kid or beneficiary also as the trustee. Because if the kid could go ahead and do something and get the money, then creditors can get the money, ex-husband-to-be can get the money, and things along those lines. If the kid can get the money, then the creditors can get the money. So what he can do is set up 2 separate share trusts for his son and his daughter, and then he can have them as trustees, but then he also would have to have a co-trustee on each of them, so the trustee would not be able, the kid, the beneficiary, would not be able to act on their own behalf, and thus those proceeds would be protected, and the trust at that point in time becomes irrevocable. If you have any questions regarding a Northwest Indiana estate planning or probate matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.